Welcome to Public Enemy Number 1, the police whistleblower. If this is your first time tuning into this podcast series, let me warn you that if you have issues with moral trauma or institutional betrayal in policing, this podcast might cause you some stress. So if you decide to listen, please find a way to release some of that stress at the end of the podcast, or maybe it's best that you not listen. There are many of us out there that are fighting battles like mine against the police. And the purpose of this podcast series is to educate the public so that more people get involved in this fight. I understand better than most people that there comes a time when we need to pass off the torch to someone else. So here we are at episode 3. If you haven't done so yet, as I always do at the beginning of each episode, I suggest that you check out my website, police-whistleblower.ca, police-whistleblower.ca, because all of the legal decisions and public court documents are published there. I also publish the decisions I've received from the oversight bodies or politicians that I've informed of this matter as well. In episodes 1 and 2, I brought you up to October of 2019. So up until this point, I had filed my lawsuit against the police service, and they had filed a case against me at the Human Rights Tribunal of Ontario. That resulted in me having to file my own claim at the Human Rights Tribunal because I didn't want their case to be heard ahead of mine. But in October of 2019, I had filed to appeal a decision in the civil court system that dismissed my lawsuit in February of 2019. I had also come to learn that the registrar of the Human Rights Tribunal was the former General Manager and Chief Instructor of the Ontario Police College, and I accused him of being in a conflict of interest in his position as registrar, participating in an application filed by the police service. I had raised that allegation before the tribunal, and I was then threatened to not make those kinds of accusations again, or I would lose my ability to defend myself in their case against me. The one thing I didn't mention in episode 2 was that along with my submissions to the HRTO, I also filed a notice of constitutional question with the Attorney General. Now, my limited knowledge on the subject is that a notice of constitutional question can be filed with the Attorney General if an individual wants to question the constitutionality of a statute. And that is what I wanted to do. I believed that Courts of Justice Act Section 137.1 was unconstitutional because it didn't provide the same protection to individuals facing lawsuits before a tribunal. But the Attorney General refused to intervene, so sadly there would be more people like me who face gag lawsuits at tribunals. So let me now take you to that day in October of 2019 when I appeared at the Court of Appeal for Ontario for the first time. I can't believe how lucky I was to be appointed a panel of 3 female judges. I had a similar experience at the Court of Appeal to that of speaking before Justice Favreau. These 3 female judges really took the time to let me speak, ask clarifying questions, and really try to understand the arguments I was making. 2 weeks later, the Court of Appeal released their decision, and I had won. Justice Doy's ruling had been overturned, and the Court of Appeal allowed me leave to amend my claim because I had been claiming that Chief Brian Larkin deliberately took action to cause me harm, but I hadn't yet pled the tort of misfeasance in public office. This was one of those times where I received some unofficial legal education, and I was very thankful for that. I had known all along that the tort of misfeasance in public office meant that a public officer did something they knew was unlawful to cause somebody harm, but I just hadn't pled that in my statement of claim. So they gave me the opportunity to correct that wrong and proceed against the Waterloo Regional Police Service and Chief Brian Larkin. In December of 2019, totally out of the blue, I was informed that I would be the recipient of the 2019 Ontario Civil Liberties Award. My dedication to making important structural changes in policing in Ontario was being recognized. I was once again reminded that I was fighting a bigger fight. This fight was not about Kelly Donovan, this fight was about police accountability. I was awarded costs by the Court of Appeal for Ontario, And I spent Christmas of 2019 amending my statement of claim against the police service and Chief Brian Larkin. I filed my amended claim in January of 2020 and waited for the police service and Larkin to file their statement of defense. I keep doing these little sidebar conversations about different issues that come up throughout my story, and here is where I'd like to talk about being a self-represented litigant. I know looking back that I've done a lot of things that the average person probably would not have been able to do, but it wasn't easy. None of this has come easy to me. It has taken hours of research, hours and hours and days or weeks on end of reading through decisions on CanLII. And for those that don't know, that's the Canadian Legal Information System. And it's where most legal decisions are published online. And I came to learn very early in this process that it doesn't really matter what our statutes say. The decisions made in court are going to be largely based on previous decisions. So even if you go into a hearing assuming that things will end a certain way, opposing counsel will find a case that resulted in a completely different outcome, and that might sway the judge to rule a certain way. Being a self-represented litigant up against a seasoned Bay Street lawyer is not easy, particularly one who enjoys using Latin just because he knows it confuses me and I don't know what he's talking about. But throughout the entire process, I have done my best to remain professional, knowing that at times it was really hard to keep my emotions in check because of my PTSD and my failing health. But in January of 2020, after I filed my amended statement of claim and waited very patiently for the 20 days to pass before the police service was due to submit their statement of defense, they hadn't done so. And at that point, I felt that the proper thing to do would be to extend a courtesy to the opposing counsel, and I sent him an email on the 21st day after I amended my claim. And I asked him when I can expect to receive their statement of defense since they were now considered to be in default. In hindsight, I wish I had simply attended the courthouse and noted them in default. Because maybe if I had, I would have actually been given my day in court for this case to be heard on its merits. But what happened instead might be very surprising to some. As I said, it was the 21st day after I amended my claim against the Police Service Board and Chief Brian Larkin when I sent the email to opposing counsel. Now, for those that don't know, in the civil rules of procedure, the defendant only has 20 days to file their statement of defense, but they hadn't done so in this case. 2 hours after I sent this email on the 21st day, the police services lawyer sent an email directly to Justice Doi. And in the email, it stated that they believed that a portion of their motion remained undecided, and they wanted it to be revisited. I don't know how you would react to getting this kind of news, but I can tell you that I was absolutely shocked. I couldn't believe that this was going to be their tactic, that they were now going to try to go back and reopen a decision that had been overturned. It was like I just couldn't get ahead in this process. As you can imagine, after my victory at the Court of Appeal in the fall of 2019, my hope was renewed. My health didn't necessarily improve, but I did have a little glimmer of hope that this was actually going to play out, that I would actually be given my day in court to hold police accountable for the way they had treated me. But this now had brought this ordeal to a whole new level. I had to make submissions about this directly to Justice Doi, which just meant more days and weeks and months of additional legal research. I couldn't locate one other case where a defendant had successfully done this. I hadn't even found a case where this had been attempted. It was starting to look very obvious to me that when a lower court decision is overruled, there didn't seem to be any opportunity to go back and revisit that decision. The only things I found that seemed to make sense were a Rule 5906 motion, which allowed a party to have a final order amended. But it seemed to be only cases where there may have been an accidental slip. The cases I could find were things like the judge miscalculating interest or forgetting to dot an I or cross a T. These were minor things. These were not going back and reopening it and saying, we want another kick at the can. We want to try to dismiss this lawsuit for a second time. It seemed that this sort of thing could also be done if the party was alleging that there had been some kind of fraud or something that had been covered up in the initial hearing of the motion. But that wasn't alleged in this case. Justice Doi eventually agreed with me that he was functus officio, which just means that he can't decide on this issue because he had already made a final decision, and this would have to be left up to a new judge. So Justice Doy's recommendation was that the police service and Chief Brian Larkin bring a new Rule 5906 motion before a new judge, which of course was what they did, and that motion was scheduled for the following year in 2021. I'm hoping that you start to get the idea of why things have dragged on so long, because my fear has always been that the public believe I'm the one that's causing this extreme public expense. Other than my desire to hold them accountable, I don't think anything I've done has deliberately prolonged this process. I simply want my day in court. I want these issues to be heard on their merits, but it really started to seem like that would be impossible when it involved a police service. So the way that 2020 began, I really felt like I was on the way to being heard. I felt like this case would see the inside of a courthouse and I would be given my day in court. But after what happened, I again became extremely discouraged. My health began to spiral, and I really didn't know how long I could keep doing this. But I knew that that was their goal. I knew that the goal was to wear me down and tire me out and just make me go away. Another thing I haven't talked about, which some of you may not know, is that in 2017, the police service was basically ordered by the government to produce a PTSD prevention plan. Now, up until then, obviously, PTSD had been a topic that was, in training and in the media, but my chief specifically had addressed the media on behalf of the police service, talking about how important it was to help first responders living with PTSD in order to try to prevent future police suicides. In 2018, there had been, I believe, 8 OPP police officers who took their lives. And this prompted the Ontario coroner to be involved to conduct a public inquiry. Now, none other than Chief Brian Larkin was the one who discussed that inquiry and the need for better protections and treatment for police officers with PTSD. So here I was, a former police officer living with PTSD that resulted from my employment with the Waterloo Regional Police Service. And not only were they continuing to take action against me that was causing my health to spiral downward, but they had even tried to eliminate the only medical care I was receiving, despite the fact that they had signed a contract that said they wouldn't. So when I talk about moral trauma and institutional betrayal, I hope that's all becoming much more clearer to you. Because probably much like yourselves, I came into policing believing that there were good people in policing, that policing was inherently ethical and honest. But moral trauma results from the shattering of our internal belief system. So based on my experience, I had come to learn that that's not always the case, which is very difficult for an individual to come to realize. My fundamental belief system was built on the fact that there are good people out there doing the right thing. But when you find yourself in a position where you try to do the right thing and it backfires like this, it's really, really difficult to reestablish trust in those fundamental beliefs. This is why it most likely results in a psychological injury and requires mental health treatment. If you are one of those people and you've chosen to listen to this podcast series, please know that there is absolutely no shame in seeking help for injuries related to moral trauma. Because let me tell you from experience, without treatment, you will be triggered everywhere. I can't even turn on the news without having some form of police corruption in my face. And without the medical treatment I've received to date, I would constantly be living outside of my window of tolerance. So as you know so far, when I resigned from policing, I had a WSIB claim for my PTSD. and they were continuing to provide me medical care. And as I said, throughout the fall of 2017, my health was improving. I actually reduced the frequency of my psychological visits, and at one point I took myself off my medication. It wasn't on the advice of my doctor. I just felt like I was feeling so good. Why do I need to take these pills? Well, then the police service appealed my claim in January of 2018, and then they filed their case against me in June of 2018. Because of all of this additional stress and my health worsening, I had to keep seeing my psychologist. My appointments were increased in frequency, and I began taking medication again. Just when I was at the point where I may have not needed any treatment at all, it was their action that caused me to continue with my medical treatment and continue to be a burden to them financially. If you know anything about hopelessness and suicidal ideation in those living with PTSD, you might have a better understanding of why I continued this legal battle. This was really all I had. If I decided to give this up and walk away, they would have effectively chewed me up and spit me out and left me with nothing, not even my health. I guess I was just too stubborn to have let that happen. So, as you know, 2020 was also the start of the COVID pandemic. So, on top of dealing with the stress of having kids being homeschooled and the threat of getting sick and dying from COVID, I was having to figure out what I was going to do about this repeat motion. I hadn't heard anything from the HRTO since their September 2019 decision, but I was really getting fed up with the fact that they were refusing to hear my request to dismiss the police service's case. So in the summer of 2020, I filed an official Form 10. Now, for those of you that don't know, a Form 10 at the Human Rights Tribunal is a request for order during proceeding. So I was formally requesting an order to dismiss the police service's case against me for all the same reasons I cited in 2018. The tribunal rules were pretty clear that once a party makes this request, it has to be heard either in person or in writing. So in addition to the submissions I had made in 2018 and 2019, they now had an official request to dismiss on file. The police service's motion was scheduled for February of 2021, and their factum very closely resembled the factum they supplied to Justice Doi in February of 2019. But here we were 2 years later, hearing an identical motion about the same matter for the same reasons. But the police service had had an extra 2 years to do additional research and come up with new arguments. It still didn't make any sense to me. I focused most of my factum on the fact that they should not be allowed to revisit this motion that was already overturned at the Court of Appeal. I had located a case that I really thought was going to be the nail in the coffin, so to speak, to put an end to all of this. The decision came from the Manitoba Court of Appeal, and it was called Lanton versus General Hospital. And in that case, there had been a full trial, and a decision was issued in the case. The decision was in favor of Lanton, and General Hospital appealed. Then the Court of Appeal made a ruling and adjusted the decision at the lower court, still in favor of Lanton. But Lanton went back to the lower court and filed a Rule 5906 motion to amend the lower court ruling. Well, naturally, General Hospital took it back to the Court of Appeal of Manitoba, and they were arguing that the Rule 5906 motion should not have been allowed. Well, the Court of Appeal for Manitoba agreed with the General Hospital and said that once they had made their ruling in the case, the lower court ruling no longer existed. So the lower court didn't have the right to adjust their ruling after the Court of Appeal had overturned their ruling. I really felt that Lanton was going to be the reason their motion was overturned. I didn't waste all of my time talking about the fact that I didn't think they should be allowed to bring this motion. I also addressed the crux of their main issue. They still wanted to have my case dismissed for lack of jurisdiction. That had been one of the grounds presented to Justice Doi, and he had deliberately said he doesn't feel the need to rule on that issue because he had dismissed my case for lack of prospect of success. But I also clearly outlined all of those arguments to Justice Bealby. Once again, it was a male judge I had for this hearing of the motion. I had already become very familiar with the decision called Weber. Weber versus Ontario Hydro is a case from 1994 that is repeatedly used to dismiss civil litigation filed by a unionized employee. Again, not being a lawyer, I'm only interpreting this as a layperson, but Weber seems to suggest that if you are a unionized employee, your only access to justice is through your union. There are exceptions to this rule, but when you look back at cases that have relied on Weber, it seems to have been used, or in some cases misused, as a blanket means of dismissing lawsuits filed against an employer where a collective agreement exists. Now, I haven't mentioned yet, but the $167 million class action lawsuit against the Waterloo Regional Police Service was dismissed. And that was largely due to Weber, but also because the judge believed Chief Brian Larkin that the HRTO is an adequate means of resolving disputes within their police service. That only made me feel worse because I was one of those people held out as a success story at the HRTO when my case had never even been heard. So I took the time in February of 2021 to explain to Justice Bealby that when I resigned, I had signed a contract that explicitly said I would no longer have any rights with my association. And there was nothing in the current collective agreement with the Waterloo Regional Police Association that required me to come back after resigning to seek redress through them. It also didn't seem to matter that along the way, since resignation, I had asked for help from the police association, and they had denied me every time. The argument was being made by the police service that I should have to proceed through the grievance procedure or at the HRTO. I also already knew that the HRTO cannot decide cases of misfeasance in public office. They only decide cases of contravention of settlement, which wasn't addressing my entire claim. Now, this hearing took place in the middle of the pandemic, but by no means was it the first virtual hearing held by the Superior Court. Still, it seemed that court staff had not been trained on the way to use Zoom so that participants can attend the hearing and simply observe. Leading up to the hearing, I had sent an invitation to my followers to observe the hearing, but I also sent them a list of the rules. You know, things like you can't interfere with the proceeding, you can't make a recording of the proceeding, etc. I had done what I believed was my due diligence to share the information with my followers, but not encourage anyone to disrupt the proceeding. Well, about halfway through the first hearing day, we started to get Zoom bombed. There were people joining the hearing that were able to share their screens, and they were displaying offensive images such as swastikas and pictures from Pornhub. It was just as disturbing for me as it was everyone else participating. But when I told a CBC reporter that I had shared the information with my followers, she somehow pointed the finger at me as if I was responsible for the Zoom bombing. There was an article published on the CBC website that basically said that Kelly Donovan doesn't regret what she did at all. And it wasn't until I called them out publicly on my Twitter account that they amended their article. But not before I captured it in PDF format. The hearing was stopped and rescheduled for a date the following week. But in the meantime, the Regional Chief Justice issued an order in our case, banning the publication of the Zoom details. The order specifically mentioned that one of the parties had shared the information on their social media. And this led me to believe that either the Regional Chief Justice himself or Justice Bealby had read the CBC article. And if they had read the CBC article, it sure looked like I was the one responsible for the Zoom bombing. The hearing resumed on March 1st, and there were no further issues. You can probably guess that I lost this motion. Justice Bealby ruled in favor of the police service and had my lawsuit dismissed a second time, and he awarded them $15,000 in costs. It's really hard for me to look back on Justice Bealby's ruling and make any sense of it. I don't feel that the arguments I made are given very much weight at all. And when it came to Lanton, Justice Bealby simply ruled that he was not bound by Lanton. There had only been one case that the police service could provide that they argued allowed them to do what it was they were trying to do. And this was the Sun Oil case. Now, you should also know that by this point in time, I had been consulting with lawyers. I had been paying for their time to help me understand what was really going on here. I wasn't just relying on my interpretation of the law, but the advice I had been given by a lawyer was that the Sun Oil case did not apply to my case at all. My understanding of the case was that there had been a hearing, there had been a decision issued in a court of law, and then the parties involved in the hearing found out afterwards that the bylaw that was applied in their case may not have been effective at the time of the ruling, or something to that effect. Essentially, the parties had returned to court to open up a matter that had previously been closed to challenge the applicability of this specific bylaw. According to this lawyer, that was not the case in my case at all. And as I said, I could not locate one other case where an unsuccessful party after an appeal had gone back and reopened the lower court ruling that had been overturned. I was really starting to believe that this entire case was a miscarriage of justice and that I was being marginalized because I was a self-represented female litigant. As with all things justice, I knew that my choices were to accept this decision and go away, or challenge it as high as I could if I believed it was the right thing to do. I was already facing a $15,000 cost award, but I really didn't know what my choices were in this case. The police service had effectively turned the tables on me and brought a case against me, and after this ruling, I didn't have much of a case left against them. I filed to appeal Justice Bealby's ruling, and it wasn't so much that I couldn't let it go, it's more that I was really starting to get curious about how far they would go to deny me my day in court against the police service. Why was it so hard to hold them accountable for something so simple? I had simply alleged that they had violated my resignation agreement on 2 separate occasions, and even the Court of Appeal for Ontario agreed with me that my case deserved to be heard on its merits. But here we were, 2 years later, and I was back in the same position with my lawsuit having been dismissed. I believed that the Court of Appeal for Ontario would see that the Manitoba Court of Appeal decision did apply in this case, and they would rule in my favor that the police service should not have been able to go back and revisit a motion that had been overturned by the higher court. You want to talk about an access to justice problem in this country? I was already facing a $15,000 cost award, and now I would be facing an additional cost award at the Court of Appeal. But what choice did I really have? And for those keeping track, at this point in time, towards the end of 2021, the police service had now spent about $450,000 on legal fees in these matters. Stay tuned for episode 4, where I'm going to take you into a deep dive of the HRTO proceedings, and we go back to the Court of Appeal for Ontario for the second time in 3 years for the same issue. Thanks for listening.